presentation. And this webinar is being recorded, and the recording link will be emailed to all attendees. This webinar is provided as an educational service by Alcorn Immigration Law. The information discussed is an overview only and should not be construed as legal advice or advice to take any specific action. Please be sure to consult a knowledgeable professional with assistance with your particular issue. Lastly, please submit any questions you have using the Slido function. That will be our Q&A function for today. And the questions will be public, so please do not share any sensitive or personal information. There's also an option to choose anonymous if you so choose. And we will try to get to as many questions as time permits. It is now my pleasure to introduce to you our CEO and founder, Sophie Alcorn, our expert attorney, as well as our founder. And this information will be shared in an email following the presentation as well. I'll take it away, Sophie.
Wonderful. Thank you so much, Alex. Thank you, everybody, for being here today. Thank you for already putting your questions into Slido. Really, really appreciate it. This presentation is navigating the tech layoffs. Help is here. Today, I'm going to give you a brief overview of some of the main things you can do to preserve your time runway in the United States, your immigration status, and your ability to work. And we're also going to talk about how you can create a startup if you're sick of big tech, and how you can get a green card without an employer if you don't want to have your life tied to a corporation anymore. So we have a lot to cover. I do have a presentation that I'll try to go through briefly so that we can focus on your questions today. And thank you all so much for being here. And for those of you who don't know me, well, I'll get to that in just a second, but there is a ton going on in tech. We've seen so many layoffs. You know, this tweet is now probably a week old, but the layoff numbers keep growing. There have been big companies, small companies affected. You know, now we've seen the Amazon layoffs start. Those might continue. Amazon was saying that layoffs might continue into the new year. So this is happening. And if you look here, you can see that, you know, in November alone, we've already had about 20,000 tech layoffs. And we've been trying to estimate the number of people who are on non-immigrant work, like visa statuses in the United States, who have been affected by the layoffs. And our estimate is somewhere between 10 and 30%. It's really hard to get that data because what we have is self-reporting of people looking for jobs on the recruiter spreadsheets that people from different companies decided to create. And initially, after the Twitter layoffs, I thought it was 7 to 10%. That's what I published in TechCrunch a week and a half ago. Now, looking at the Meta list this week, it appears that 26% of the individuals who self-identified on that list do require some sort of immigration sponsorship. But that list reflects about 2,300 people, which is not the full 11,000 that Meta laid off. So it could be an over or under representation. It's hard to know. I think that it's, though, particularly stressful. We're going to be talking about the 60-day grace period. And I think that people who are looking for jobs are more likely to be people on non-immigrant status than people with citizenship or permanent residence. But if you were laid off and you're on an H-1B, you are not alone, and there are absolutely things that we can do to help you and that you can do to help yourself. And that's what we're going to be talking about today. My name is Sophie Alcorn. I'm the founder of Alcorn Immigration Law. I have a weekly column in TechCrunch called Dear Sophie. This has been a crazy week, and I would love your help if you're here on this webinar and you are either a recruiter or employer looking to recruit laid off individuals, or if you were somebody who was laid off yourself and you would like to, if you would be open to sharing your story with reporters, You can do it anonymously, and in the last 72 hours, I have been nonstop on interviews with the New York Times and USA Today, and last night the BBC and Voice of America, Forbes, The Verge, The Information. All these publications really want to cover this, and they don't just want my legal analysis, they want human stories, because these reporters understand that there's a huge human cost of our messed up immigration laws. So if you feel inspired to share your story, you can send me, or probably best to just DM Alex here in the chat panel, and provide your email and whether you'd like to be anonymous, and we would love to connect you with some of these reporters. And you don't have to say your name, and just any information that you would share in the world would really help move this conversation forward for people, potentially change the 60-day grace period and lead to immigration reform. I was on ABC 7 News in San Francisco the other day, and I'm sharing that story with lawmakers, senators, representatives in Congress to see if we can actually get some meaningful legal change here to help people at scale. Okay, so what happens? What is going on? Let's dive into it. I'll go through the presentation, then we can get to your questions. There is this 60-day grace period. It is only 5 years old. It was created by USCIS regulations. You have 60 days, and so you really need to think about how to navigate this. And some of the considerations are, number one, okay, what is the 60-day grace period? It is a discretionary option created by regulation 5 years ago. It is not guaranteed for anybody, although I have never seen USCIS deny the 60-day grace period for anybody. It's not something you apply for specifically. It comes into effect when you're seeking your next employer who's transferring your visa, or if you're seeking to apply for a change of status. At that point, USCIS will want to ensure that you have been maintaining valid immigration status. And typically the way they do that is they ask for your 3 most recent pay stubs and your most recent status. And so this grace period applies for people in H-1B or L-1 or TN. There's a variety of non-immigrant work visa statuses. It seems that most people are on H-1B who were laid off. And so this means that you have 60 days from the date of your cessation of employment to find a new job, figure out a new status, or leave the United States. Now, sometimes people ask me, okay, Sophie, but Twitter failed to give notice of the layoff that it was coming. And so we're going to be paid. I'm going to get paychecks into January. So can I count my 60-day grace period as starting then? And I would say, no, that's not safe. I mean, you of course, you could try anything. And if your company that offers you a job in the future and their immigration lawyers want to try to use those 3 most recent pay stubs from February or whatever, yeah, you can try that. But this is discretionary. USCIS is well aware of these mass layoffs. The dates for all of them are very publicly known. So you might find yourself in a situation where your change of employer is denied and you have to leave the country for consular processing. And so I think it's risky to try that route. And that's something that you would have to consult with the immigration lawyer from your company that will be offering you your next job. You're going to have to figure out with them how you're going to handle that. But I think it's safest to treat the 60 days as starting as the day you found out that you were laid off, because that's the most conservative way to approach that clock. There's definitely a 10-day grace period that's not discretionary, but the 60 days technically is discretionary. And I just think it's really important to consider all your options to remain in the United States. People who are laid off have lived here for, years, potentially, gone to school here since undergrad, might be married, might have US citizen kids, might own homes. You're, part of the fabric of US society. And so we need to do whatever is necessary to be able to create peace of mind and keep you in the United States through this time. And so that's what we're going to talk about. There's a lot of ways to do it. Okay, so let's demystify your options. So there's a lot, and because of the AMA format, I'm going to kind of go through this at a very high level. If any of you follow my stuff, you'll know that I can talk about all of this for hours and in as much detail as you want. So I will do a high level now, and if anything strikes your interest, we have plenty of time and I'll be happy to dive into any of these in more depth. Okay. So for an H-1B transfer, here are some of the key points that you need to be aware of. If you are on an H-1B and you got laid off and you have used less than 6 years of your original H-1B status, you don't have to go through the lottery again. You can simply be on your 60-day grace period, and as long as you find a new company that will file a change of employer petition and USCIS receives it by that 60th day, then you're maintaining valid status and you can start working at the new company the day USCIS receives the new petition. Law firms interpret that differently. The date of receipt could be like, oh, we got the FedEx notification that the package was dropped off. That's like the more risky way to start work again. The more conservative way would be to use premium processing so that your lawyer will get an email receipt notice of your petition from the government when they've actually processed it. That's the safest thing. That's fastest. Premium processing is $2,500. If your future company doesn't offer it or require it, then you can add it in and pay for it individually as the beneficiary. But that's the only H-1B fee you're actually allowed to pay for as the beneficiary, and they can't dock your wage or take it out in any way. And if you have used more than the 6 years in H-1B status, or you're coming up to your limit, then your future company will need to be well aware of where you got in the perm process. Do you have a priority date? What is it? When was your I-140 approved? Have you started the I-485 green card process yet? So the more you can do to get all of your documents super clearly organized in your own cloud storage system, the easier it will be to facilitate this H-1B transfer. You should start interviewing now. I think that it's safest to try to get an H-1B transfer filed by the 60 days. I think it's safest if you can accept at least a verbal offer by day 30 of your grace period. And I know that's really tight with Thanksgiving next week and hiring freezes. But unless you're at like a massive company at which there's a lot of hiring freezes, especially for an early stage company with funding, but maybe they're new to immigration, it can often take 2, 3, 4 weeks to get their very first H-1B petition ready. There's some extra steps that a company would have to do for the first time. So the sooner you can get everything started with the new company and their immigration lawyer, the better. And we're certainly available to represent any companies that are hiring. And in fact, we're offering $1,000 off an H-1B transfer to show our solidarity for everybody in this time. So please, if you're at a company and you're hiring anybody who was affected by the layoffs, please contact us, and we'll be happy to provide that discount as well. Because we know that even companies that are hiring right now are probably trying to conserve cash and preserve runway, just to, be conservative in the months ahead. So that's really the H-1B transfer. You should start interviewing now. There are a ton of recruiters specifically reaching out to people who were laid off. And I just think that the sooner, if you can try to get an interview before Thanksgiving so that you can negotiate the terms and get that offer letter like the first week of December, and then initiate the H-1B that week, that's probably going to be best for most people who've been laid off in the last 2 weeks. Okay, so what happens if you can't get an H-1B offer on time? So this is where this becomes a little bit more of an individual analysis. If you have a spouse who is on another non-immigrant status, you could certainly look at filing a change of status to become a dependent on that spouse's visa. Like if you have a spouse who is on an F1, you could become their dependent. If you have a spouse who has their own H-1B, you could apply for a change of status to H-4. If they've gone through enough stages of the perm and the I-140, you could potentially apply for a work permit through them. So that's really nice. The H-4, the good thing about that is you get the validity. Your duration is as long as your spouse is maintaining their H-1B. So that's potentially longer than becoming a visitor, which is the next thing I'll be walking you through. But the other thing I just want to point out about people who are married and they were laid off and they're on an H-1B, let's say your spouse is on an H-4 and your spouse has a work permit, their status is dependent on you. So they are allowed to be working in H-4 status and be in the United States as long as you are maintaining valid H-1B status. So what that means is the conservative thing is if the 60-day grace period is over and you haven't had a new company file your H-1B, the safest thing is if they stop working for their company. And I know that's a double whammy for families. The system's super messed up. The one thing I would offer to people in that situation is that if your H-4 EAD spouse's employer wants to keep your spouse in the country and working at that company, they could work with us through Open Avenues Foundation to get an H-1B for your spouse without the lottery, so that your spouse can go from H-4 work permit to their own cap exempt H-1B to continue working. And then you could be on an H-4, and whether you could work or not is another function of that. If you're not married, or if your spouse doesn't have any of those options, then the next thing to look at is really becoming a visitor to buy 6 months of time runway so that you can continue interviewing past the holidays. And hopefully some of this will calm down in January. And then you'll be able to take more time to examine your options. So the B1 is visitors for business. The B2 is visitors for pleasure. And so with this, okay, so you might already have a B1, B2 visitor visa in your passport. They're often valid for 10 years and for multiple entries. This is a little bit different. What I'm suggesting here is a change of status application so that you don't need to leave the United States right now and you can stay here. We are recommending starting this process now and requesting the 6 month, it has a maximum 6 month validity, and the 6 months could start on, day 59 or day 60 of your 60-day grace period. And you could file this now just to know that it's, going to be received by the government and it's going to be pending. And if you get an H-1B transfer filed before day 60, you could withdraw your change of status application to B1 or B2, and we could help you with that as well. So a weird thing about the B1, B2 is that USCIS does not have premium processing, and it can take them 6 to 8 months to make a decision. We had to do a lot of B1, B2 changes of status and extensions for people in the pandemic who got stuck in the United States and couldn't travel internationally. And it's just really weird because your approval notice might come 1 or 2 months after the duration of status that you requested. So it is possible to do a subsequent change of status. Let's say you get an offer in February or March and you're in that requested B2 pending status. That employer could file a change of status for you from B1 back to H1B. But the thing is, if you get your H1B change of employer filed in your 60-day grace period, you're allowed to start working at the new company when USCIS receives the new petition because you're already maintaining valid H status. But if you've filed for a change of status to B1 and it's pending, and then your subsequent employer files another change of status from B1 to H1B for you in March, you will not be in valid H status. So you need to wait for the premium processing approval to be able to start work at the new company, or at that time, if you have a multiple entry H1B visa, you could potentially use the approval process to exit and re-enter with the I-797 approval notice, or you could talk to your immigration lawyer at that time about getting a new H1B visa. So there's a lot of branching forks on the decision tree to be mindful of as you navigate this process, but the B1 is going to be great well, okay, let me just start with B2. B2 is for visitors. You're not allowed to work. You should not be doing startup formation. I think it's okay to look for a job as long as all you're doing is going to visit family or doing like a meditation retreat or whatever you need to do for your mental health break to de-stress and recharge. That's all okay on a visitor status. But if you want to use this time period, and we'll talk a little bit more about like immigration independence and becoming a startup founder, if you want to use this period to rack up your accomplishments for an O1 extraordinary ability visa to be the CEO of a startup, or have a gig, an itinerary with multiple gigs and multiple companies where you're working, or you want to try to self-petition a green card and you need more accomplishments, I would really recommend a B1 status for that, because you still can't work, but with B1, you're allowed to do the activities of a business visitor. You could own a business here. You can talk to venture capitalists. You can publish articles for free. There's a lot of stuff you can do to build your portfolio of accomplishments. And we'll talk about that more. But on that note, we have our online class, Extraordinary Ability Bootcamp, which walks you through all the requirements and the steps that you might need to take to build that strong, robust application. And I know many people who have done all of that without the ability to work as students, for example, so it's definitely possible. And then we also have our legal launch program, which I'll tell you a little about, which is where we will do a deep dive and verify your credentials. So those are some of the reasons why and how you could use change of status to B1, B2, and try to get more time runway in the United States. So now let's talk about green cards, because the H-1B it's a big trap for people, and I think a lot of people want to get out of it. I don't have any more recent data on this, but in like 2018, the Cato Institute was ballparking that if you were in EB2 India, it was going to take 150 plus years for you to get your turn in line on the visa bulletin to get a green card. And yesterday we were looking at the numbers for the December visa bulletin from the State Department, and there's retrogression. So it's slowing down and getting more backlogged for the categories we're going to be talking about. So we'll also discuss how another option is to self-petition a green card within your 60-day grace period and get your adjustment of status application filed as well. Okay, so we work with a lot of founders, but you can self-petition a green card if you're not a founder. You could do it as a researcher, you could do it as a professional. There are a variety of options. In general, if you've been laid off and you're thinking about what is happening to your green card, there's a lot of things to consider. Also, If you're laid off, your colleagues who were not laid off, their perm process is going to be affected by your layoff. So, there's going to be a lot of repercussions of all of this for many months to come for a lot of people. So first you want to know your priority date. That is either the day your I-140 was filed in the EB1 or EB2 NIW category, or it's the day your perm was filed in EB2 or EB3 if your I-140 got approved. So you want to know what your priority date is, what category it was for. You want to know what country you're chargeable to on the visa bulletin. It's usually your country of birth, or it could be your spouse's country of birth, but it's not either of your country of citizenship. If your priority date recently became current and you filed your I-485 already, and if it's been pending for at least 180 days, you will probably already be on your way to a work permit combo card. And you can port your I-485 to another company that's in a same or similar occupation. And that might mean that they don't have to do an H-1B transfer for you. Although I usually recommend it just to keep everything super safe and secure for you. If you were born in India or China and you want to get a green card and you need to do it independent of a company and your priority date is backlogged, then we're going to be talking about the EB1 category for extraordinary ability. And if you're from another part of the world or your priority date is current, then it's easier to get an EB2 national interest waiver green card. So here are some non-H-1B options that we typically offer for people who are somehow related to the tech field or the startup ecosystem. These are really great because they can give you a lot of autonomy and independence from the corporate immigration process. And it can be hard to transfer your own H-1B to your own startup if you want to become a founder. So the O1 can be a really great option. So to go into these in a little more depth, the O1 is a visa, the EB1A and EB2 are green cards. A green card is valid for life. I mean, the card itself expires every 10 years, but the status is for your life. An O1 is usually in 3-year increments and you can renew it indefinitely. Some of these have premium processing, but the whole process, like to get an O1 from start to finish, if you're already qualified, maybe in the country or maybe need to go to a consulate to get a visa, the petition can be approved in 2 weeks by USCIS, but the whole thing typically takes like 6 months. But as long as you file that petition by the end of your 60-day grace period, then you maintain your status. The green card is typically a 2 to 3 year process. We would, to maintain your status with a green card beyond the 60-day grace period, we would need to file your I-485 by the end of your 60-day grace period. And in order to do that, your priority date has to be current. And if you don't have a priority date yet, that's okay, but it's not going to work if you're from India or China, most likely. But if you go through our legal launch evaluation program, we will let you know your specific options on all of these things. The EB1A and EB2, you can self-petition, just sign the forms yourself saying like, I'm asking for my own green card. I think I'm important for America, or I think I'm super accomplished. The O1, you need to have an employer or a petitioner file for you. If you don't have one, but you have work that you want to do in the United States, we can support you with finding an agent. And with an agent-sponsored O1, you can have a whole itinerary of services, and I'll go through what that means. But essentially, you can be part of the gig economy, you can have advisory shares, you can be a venture scout, you can get book revenue, royalties. You could do a lot of things with an O1 itinerary of services. All right, so let's talk about like 3 groups of people and what journeys they might go through in navigating this. So international students, there's a limit to the number of days of unemployment you can have. So please monitor that closely with your school. It's different if you're on OPT or STEM OPT. But remember, if you're on regular OPT and you just got laid off, you don't have to have paid employment. You can maintain your status with volunteering. And if you need nonprofits to volunteer for virtually, I can hook you up. If you're on OPT and you're trying to put together your next employment, you can be a startup founder. You do need some sort of advisor to advance you within your field. It needs to be at least part-time work, and there's no like H-1B prevailing wage, but you do have to earn at least minimum wage for 20 hours a week on STEM OPT. And all of this is a time to build your portfolio, to bypass the whole corporate immigration thing of H-1B and perm and all of that. One thing I just want to point out here is I have no idea what's going to happen to the H-1B lottery in spring. Last year, there were 482,000 registrations for 85,000 spots, which was the highest ever. With the hiring freezes, there may be less in spring. So if you do have an employer at that time that can sponsor you for an H-1B and you don't have one yet, if you need it, this might be a very good year to get an H-1B and be in the lottery. Better odds than last year, certainly. Okay, so if you know that you are at the beginning of this portfolio of accomplishments situation for an O1 or even an EB-1A or EB-2 green card, I just want to briefly go through some of the most common criteria. We work with a lot of startup founders, as I mentioned, people in the STEM fields. You need 3 of these 8 categories. You don't have to have graduated from college to qualify for this. Startup founders can often do it. Researchers and postdocs can often do it. There are a variety of ways to qualify. Just briefly, for a startup founder, a compelling winnable case might be you won TechCrunch Disrupt and you got $3 million of investment from a well-known VC. You're a member in Y Combinator or Techstars or 500 Startups or Founders Network. There was 1 TechCrunch article and 1 Business Insider article about your company, or 5 articles in your home country. You got invited to judge 1 or 2 hackathons or pitch competitions. Maybe you have a pending patent. You've developed something original. It's disrupting your field, and we can say that that's significant. Maybe you've written several articles in an online magazine or business journal or newspaper, and you have a founding role at your startup. And then your compensation, we can multiply a valuation of your company by your shares and demonstrate the value. So you only need 3 of these, I want to emphasize. And if you have an academic background with publications that are peer-reviewed and citations, then that's another type of portfolio that also very often easily works for this as well. And if you don't have any of this yet, your 60-day grace period plus 6 months of B1 status is more than enough time for somebody who's highly motivated to build all of this. And yeah, it's just because that wait time takes so long for people in the normal categories, especially if you're from India or China, as a lot of our clients are. So if you're not from India or China, I do want to point out, or if you're from India or China, but your priority date is current in EB-2, the EB-1A is very much like the O1 in terms of self-petition green cards. The EB-2 NIW, you can more easily qualify for. You either need like a master's degree, or you need to show exceptional ability, which is way easier than an O1. And then we just have to show your plans for what you're going to do in America once you have your green card, and it has to be in your field. We have to show that it has substantial merit and national importance. We have to show that you specifically are well positioned to advance this endeavor. We have to show that it's good for the United States if they don't try to substitute you with some random American person to do this job instead of you. We've done this for startup founders. We do this for inventors. We also do it for translators that do localization, and UX UI designers and festival arts planners. So there's a ton of stuff that could qualify for this. If you have to leave and you don't have a visa and you need to come back in and you can qualify for an O1, It's probably going to be the fastest new type of visa to get without the lottery or a job offer, if you can put together an itinerary of services with the agent. And that brings me to this aspect. So especially if you're from India or China and you need to position yourself for an EB-1A green card after you get an O1, can be really valuable to have work authorization in multiple companies, not just like the traditional one petition, one company employer model. So we do this with startups. It's borrowed from Hollywood and movie stars, but there are agents that can sponsor your O1 petition, and they can put together an itinerary of services for you to work on in your field during the 3-year requested time period. So that means that in addition to being the founder and CEO of your company, and being an advisor and getting equity in your friend's startups and getting, 1099 income as a contractor for being a paid speaker and maybe doing some consulting work in your field and being that venture scout that I mentioned, you can make money off of all of those things. You can be a day trader, like as long as it, somehow lines up with your field, we can get it all in there, and then it's valid, authorized employment, and then you can use all of those new accomplishments for your EB-1A, and you don't have to be scared that like, is this authorized or not? I don't want to risk that one of my accomplishments that I'm highlighting to the US government was something that I wasn't actually authorized to do. So this can be very valuable as well. So if you need some guidance, I've come to the right place. I know that we have employers on this webinar as well, so I'll just reiterate that discount. We are very happy to help, but the sooner you contact us, the sooner we can make sure we have capacity. We do all of the things I mentioned. So if you need to apply for a change of status to H4, or B1 or B2, or apply for a work permit, or you want to try to get a green card by yourself, we can help you with all of that. If you're a tech startup or another company that's hiring and you want to get some of the brilliant people who are laid off onto your payroll as soon as possible, we can certainly support with that as well. We do H-1B transfers and TNs and Ls if you qualify, and other types of work visas, and we can help navigate for any one of these categories. So this is our contact information. Please contact us, and you can also reach out to my team in the chat window, which is different from where we're going to be answering questions in just a second, which is in Slido. So just and we'll be putting this information in the chat window as well. Okay, great. So with that, let's go into all of your questions. And remember, you can upvote these. The QR code on the left is our Slido link. So if you go there and you see that somebody else's question is important to you, give that an upvote now. And then this will automatically sort so that we can go through them together. All right, let's see how many of these we can get through. Okay. So first question, if you move to an H-1B to B1 in the United States, do you need consular processing for the H-1B once you get a new job? What happens if you leave the US during this time? Okay, let me take these one by one. It depends on how your lawyer and the company decide to set this up for you and with you. You can be part of the conversation. Usually the easiest thing that people want is to simply stay in the United States. That means that, so in this scenario, you're here now on the grace period. You apply for your own change of status to B1. Subsequently, in those requested 6 months and beyond the 60-day grace period, a new company has offered you a job and they are filing your subsequent change of status back from B1 to H-1B. That is how you would stay in the United States. So that's the way to file it without needing to leave the country. Hopefully, USCIS would just approve the change of status from B1 to H-1B. Sometimes they approve things out of order. If they approve the H-1B, you're allowed to start working as soon as they approve it. then you have to wait for the decision on the B1. If the B1 is ultimately approved, everything is retroactively fine. If the B1 is ultimately denied, then you would need to leave the country, make sure you have a valid H-1B visa, and come back into the United States with your existing I-797 H-1B approval notice. If you want to do this differently, where you definitely plan on international travel, then you could simply file the new H-1B for consular processing. When you get the approval, you could depart the United States. And then if you already have a valid multiple entry H-1B visa in your passport from a prior employer, you can use that plus your new I-797 approval notice to come back in. And if you don't, then you would have to go through the process of obtaining a visitor visa in your passport through a consulate, through a DS-160 application. And that can either, that in 2022, we still have the option of the State Department waiving the requirement for an in-person visa interview because of the COVID backlogs, but I don't know if that discretion will remain in 2023. So if you don't have a valid visa already, it's probably safest to try to do this whole thing in the United States and only leave if you absolutely have to. Okay. Great. Now, oh yeah, and what happens if you leave the US during this time? Oh, there we go. You will abandon your change of status to B1, B2. So that is also something that you would want to carefully consider before you depart and do in consultation with an attorney. Thank you so much for that first question. Great, and I see more questions and more votes coming in, so thank you so much. All right, next up, what are some of the risks involved with transferring from H-1B to B1 and then back to H-1B in terms of the timeline? Well, I mean, first of all, like you would do it, like if you want to leave the country and not mess around with this, you could certainly leave. Like I know people who got laid off and somebody back home passed away on the same day and they just have to go and they need to be home with their family for the memorial service and they don't know when they're going to come back and they're going to do their job search from abroad. That is certainly fine as well. I just know so many people who are, you know, friends and in my community who live in the Bay Area who have spouses and houses and American kids, and it's a big deal to travel right now. So they're trying to preserve their ability to remain in the United States. So that's why you would want to do this. Okay, the risks of transferring from H-1B to B1 and then back to H-1B in terms of the timeline. Well, I mean, the risk is that the B1 gets denied. You know, nothing with USCIS is ever guaranteed. So all we can do is, you know, rely on our experience and knowledge and detailed consultation with you to help you put your best foot forward with these processes and give you the best chance of being approved by the government. So the risk is that the B1 gets denied and then you are, and it's this chain link fence. It's this, excuse me, linked. It's a chain made of links. It's that analogy that my dad taught me. You can get the links placed in any order, but they all ultimately need to connect so that when you pull, the chain remains connected. So in that scenario, you have your first H-1B that needs to be connected to an approved B1 that needs to be connected to an approved H-1B. And the government might approve those in different orders, but ultimately they all need to be approved. And the H-1B allows for premium processing. B1 takes, you know, 6-10 months, who knows what, to be approved next year. So the risk is that you get the H-1B, well, you know, if the H-1B is denied, then you have to leave and try it again. And if the B1 is denied, then you have to leave and come back in. But as long as the B1 is pending, you are in a period of stay authorized by the Attorney General. You're allowed to be here and wait. So I hope that clarified that. If there's more specific things that you need me to touch on, please feel free to add more follow-up questions to that. Next, we'll go to this one. Is it better to do a change of status within the US from an H-1B to a B-1 while unemployed, or is it better to leave the US and come back in with a B-1 at the border? I think it's safer to stay in the United States in general, but it depends on your country of citizenship, your country of residence, whether you have a valid B-1, B-2 visa in your passport, and when it expires. If you're from Canada, then you don't need one. But if you, this is where that concept of immigrant intent can come into play. The H-1B is a dual intent status, and if you have the green card process started and filed, that is an indication of your immigrant intent. And intention matters at the time of entry into the United States. And so it's much more likely that a border officer or CBP officer at the airport would say to you, why you were just living here and working here and you wanted to get a green card and you left and you're coming back in as a tourist? No, go back to your home country and wait till you get another job. I still don't think anybody should leave the country unless they have to, because everything is super backlogged from COVID still. And if you leave, we can't guarantee when you're going to come back. So I think it's safer for you to stay here. But now obviously everybody has to make their own trade-offs. If there's a family emergency or a health situation, or you're burned out and you just need to be back home with your family right now, of course, those are all things that are important to take into consideration in this balance. Can you confirm that this route would work if my current H-1B is EB3 with a current priority date from H-1B EB3 to O1 to EB2 NIW? I'm going to unpack that for a minute. Okay, so I don't know your priority date, but your green card is in the EB3 category. So you probably have a perm that got certified and an I-140 that got approved, and you're waiting for your priority date in the EB3 category, and you have an H-1B, and you're wondering if you can do a change of status from H-1B to O1. Yes, you can file it in your 60-day grace period if you qualify, or you can add another link to that chain and request another 6 months of B1 first to improve your O1 credentials if necessary. And then yes, once you are on an O1, you can self-petition for an EB2 national interest waiver green card, and we can reuse your priority date from your prior EB3 green card process. So it depends on what country you're from and what your priority date is, how long you would have to wait to ultimately get your green card. But this is a very common and successful route for a lot of people. So yes, we had to decipher it, but this is great and it works. And I would recommend that if you're curious about the O1 and you think you could qualify for this, please contact us. You're the perfect candidate for our legal launch program. That's the first step for any O1, EB1A, or EB2 NIW at Alcorn. And it's a 3-week process where we gather all of your evidence of your accomplishments. We do a 3-step internal evidentiary review, and it culminates in a legal consultation, and we'll answer your questions along the way about travel and processing times. And that's where we'll be able to sit down at the end and let you know if you qualify to be our client and upgrade to the full petition, or if you need to do specific things, XYZ, to become qualified so that you have a winning case when we file. I won the H-1 lottery, but hadn't enacted it yet. Can a new employer do a change of status as well as a change of employer? Any risks? How does it work? Yeah, we've done this. It's very rare, but I've done it multiple times in my career, and it's always been fine. We have to show that you were already counted against the cap in the lottery. So with an approved I-797 for consular processing from an old company, you check that box. Now, the new company, if you're in the United States, and let's presume that you're probably on OPT or STEM OPT, F1 student here. If you get a new job, yes, the new employer can do a change of status from F1 OPT to H-1B and request it. So it's a change of it's a change of employer, first of all, and it's a change of status, not consular processing. We've done this. We're happy to help. And I guess the risk is if for whatever reason there was a request for evidence, we would simply respond. I haven't seen any issues with needing to depart, but I mean, this has always worked for me as a change of status for people without any issue. But I guess the risk is that if they say no, go consular process, then we would find you a consulate to go do a visa interview in, and we would plan that travel. And the longer of OPT runway you have, then the more time we have to book that appointment abroad. So I think that's great. Yep, absolutely. Okay. How do I best prepare my family while I attempt to transfer my H-1B? Oh, I love this question. We have 7 more questions, and I love to answer all of these. And I'm talking to another reporter in a few minutes. So I got 4 minutes to answer these. So let me see what I can do. How do I best prepare my family? I have an 8-year-old and 11-year-old. I think just being present, compassionate, loving, meditate. This is stressful. Acknowledge that this is a strain on everybody. They know you're trying your best. And I think there are a lot of really wonderful companies out there who would love to hire people. And there's a lot of really compassionate Americans who know that this is a hard time and they want to use the power they have in running and owning companies to be able to help people. And I hope that you're able to connect with them so that they can do your transfer. Your kids can stay in school on B1, B2 if you are, and they're probably US citizens, so that's all fine. We're happy to talk more. If your kids are on a B1, B2, you're not supposed to enroll kids in school in most states if they have just registered for the school and you're visiting. That being said, I know that there are many people in California who go to public school who are on B1, B2. The schools don't normally notice or ask. And from a government perspective, I have never seen any problems with a child for their future immigration status if they remain in school on a B1, B2. But please talk to us directly. I was on an F1 before getting on an H-1B. The F1 expires in July. Can I transfer H-1B to F1 without leaving the country and get everything before the grace period? You need to get accepted into school. You need a new I-20. And then if you have this valid multiple entry F1 visa in your passport until next July, it's probably going to be quickest to leave and come back in as an F1 student. If you already have a green card process started, you might want to rethink this because of the immigrant intent issue. The change of status from H-1B to F1 inside the US is notoriously long, and you'll have to always delay your start date and get new I-20s. So if you can avoid that, that would be helpful. How to handle the layoff being in first year OPT F1. Find a place to volunteer immediately so that you don't accrue unemployment, and then you maximize your time to find a new job. Make sure you continue to update your records and see this and tell your DSO. Can I get a visa and a path to a green card and citizenship eventually via my startup? I'm Canadian. It is a Delaware-based corporation with a headquarters in Miami. Absolutely. Please contact us. Legal launch, fastest option. O1 for founders, better than all the other options that Canadians luxuriously have. Happy to chat more. Thank you for the feedback on Slido. It's a new tool, so we appreciate it. And we're always looking to improve, so we appreciate it. If you need to do a change of status at the consulate, they would ask if you've been laid off. Would this stop them from approving the H-1B? At a consulate, you would not do a change of status. You would file for a new visa. The change of status is something you only do inside the United States when you're already here in a status, changing to another status. If you're at a consulate, you're applying for a new visa. They want to know that you didn't overstay illegally, but getting laid off is fine and being in the grace period is fine. If you're overstaying a long time beyond the 60-day grace period, that could screw you on a subsequent visa interview at the consulate. Do you have a free consultation to discuss my goals? I find it difficult. Thank you for the feedback. Our consultations are typically $150. This is a recent decrease. We used to charge $300. We wanted to be able to help more people, and you're welcome to reach out to us. We would love to help you. And yes, we will be sharing the recording with everybody. Well, thank you so much. Thank you for attending. We appreciate you. Be well, keep in touch, and we look forward to supporting you. Thank you so much.